Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss jurisprudence class. Our topic for today is lecture number 14 in jurisprudence is interpretation. Friends, I will deal with the topic interpretation separately for an entire semester in the next semester for the second year students. But in a nutshell, we will learn what is interpretation. So to interpret means, for example, if you see the film Sita Ramam, then the interpretation is regarding Geneva Convention, where Prakash Raj says the Pakistani people, they are not going to implement the Geneva Convention. Like that. When you see the film Kantara, so the last scene theory, when that Guruva is accompanied by the so-called Zamindar and both of them get to go together, but ultimately only one person comes back. This is what is called last scene theory. You will be understanding more by the so-called visible audio means. So before that, the interpretation is necessary in legal aspects. Why? Because legal language is different from the ordinary language. Legal phraseology, nociter esosis. So can a man who knows English, can he explain the legal phrase? Very difficult. So whenever, because the sentences of law, they are very complex. And you will get a doubt whether it is may, whether it is shall, or things like that. Whether it is he, whether it is she, so many doubts you will get. Then who is there to clarify? So in such a case, interpretation is necessary. And friends, the main job of the court, the primary job of the court, particularly the High Court and Supreme Court, is to interpret the law, to explain the law, to clear out your suspicion, to clear out any doubt. There are so many methods also. Suppose if any judge gets a doubt on particular validity of an act, he can refer the matter. It is called reference. Section 150 of the CPC, like that. But here, interpretation. So please remember, even suppose if you get a letter from your friend or some agreement, so you will get a doubt, is it not? Then you will ask him. You can you will ask him as to what he meant, and he has to explain. So that is what is called interpretation of the statutes, right? In this connection, I want to tell you that the people who make the law, who prepare the law, they are definitely intelligent people. Normally, I will be commenting that those people who sit in AC, who do not know the practical difficulties of the common people, they write the law. It is not correct. They know. They will prepare the law, but they will think in all aspects. Suppose if this thing happen like that, then only there will be some ambiguity. To clear out that, the interpretation is necessary. Why? Because there is obvious ambiguity in the words used in the sections. Then poverty of the language of the draftsman. Of course, this is not correct, I can't say. But want of imagination in not providing for conceivable situation. This is what is called saving clause. Other matters, like that. And due to inept and ineligible language, this is not correct, okay, whatever it is. So different types of interpretations are there. The first one is grammatical interpretation. It's called literal interpretation. That means if you know the grammar, you can easily understand, but sometimes it becomes difficult. Very simple example I tell you. Very recently, Honorable High Court of Karnataka said victim means, according to section 2WA of the CRPC, victim means a person who suffered injury in the hands of the accused, a person who suffered damage due to the act of the accused. But the literal interpretation has gone to an extent that you can include the legal heirs also. So this is in one way, I will tell you that the particular term comes, but as far as this is literal interpretation, not only the victim, her relatives, they are also victims. This is what is called literal interpretation. Likewise, very famous case is that Shankari Prasad versus Union of India. So this is as regards the so-called abrogation of Article 31, that is 19, right to have property, and include the same in Article 300A of the Constitution. There is a lot of commotion. So in this case, Shankari Prasad case, whether the government has got the power, whether center has got the power to amend the constitution as per Article 368. So, a grammatical interpretation of Article 13, Clause 2 says it is also a law. So, this constitution is a law. It cannot be amended. So, this is the interpretation. When people got doubt, they have cleared the air. But please remember, later in the second interpretation, this is called golden rule of interpretation. Golden rule of interpretation. Golden rule of means when there is a confusion, the words should be taken their original meanings. Here the point is the words change their meanings like that of a chameleon. So therefore you have to understand the real meaning of the words and put them side by side so that the golden rule will prevail. So for that the best example is Golaknath versus State of Punjab 1967, where the court stated that yes, Article 13 Clause 2 law, so amending power is also law as per Article 368. Yes, the constitution can be amended. Ultimately, in the case of Keshavananda Bharati 1973, what was stated? The center can amend the constitution, but the basic structure should not be disturbed. So this is the golden rule, is it not? Then we'll come to the topic of Ejusdem generis. Ejusdem generis means, Ejusdem generis means, please remember, this is, please remember, whenever a list of specific words are being used, whenever the specific words are being followed by the general words, the relative meaning should be given. I have given the example. Suppose if the mother gives 100 rupees to the boy and asks him to get some vegetables, if he gets, if the rate of them is only 80 rupees and 20 rupees or less, then if he asks her, you get something. So something is what? Some vegetables like carrot, like beetroot, like that. But not the so-called, I told you, yes, jokingly I told you, but not the beer bottle. So of the same kind. This is what is called Ejusdem generis. So this is also a very good rule of interpretation. Actually, this was envisaged in the year 1938 itself in the case of Evans versus Cross. Evans versus Cross, this is a US case where the Ejusdem generis is regarding the traffic signals. So traffic signals, what you understand, normally you say that if the bleep of the yellow or green or orange is there, then you will proceed. That is a traffic signal. Suppose the constable waves his hand, this is a traffic signal. But signpost is also a traffic signal. That means if you are going to, in the highway, you will be, on the road you will be understanding. It is upland or right intersection is there. They are also traffic signals. So actually this is another point. Or the speed gun, it is also traffic signal. It includes the other devices. So don't say that traffic signals only those signals which we are able to see. So this is what is called Ejusdem generis. This is applied in Siddhesari Cotton Mills versus Union of India. I think it is in the year 1989 if I am correct. So there the dispute is regarding bleaching, drying, dye, printing. All these things, they are specific, general words. So bleaching is followed by printing, dyeing, all these things. Otherwise, the cloth will not come out. So this is the Ejusdem generis. Then we will come to mischief rule. This is most important. Mischief rule of interpretation. So mischief means, please don't be understand that there is a mischief. So what is the mistake? For the mischief rule, please remember, in some cases, difficulties will arise in the interpretation regarding the construction of sentences, phrases and their true meaning. The true meaning has to be elicited. So Hayden's case is already 9 minutes. Hayden's case is the best one. So in the particular Hayden's case of 1584, actually a college run by a Christian institution, it has got some properties in its own name. They have employed actually one person and actually they have given a house to him and his relatives. But ultimately, after some time, the property was taken over by Hayden. Hayden has become the contractor of the property. Then, while he was making arrangements to put all his people immediately Henry VIII clause came there, entire properties will go to the state. So in such a circumstance, Mr. Hayden asked the warden to vacate, and Mr. Hayden filed a case against the so-called Henry VIII clause. So now what to do? Already the college management has asked him to stay in the house forever. At the same time, Hayden did not take care of it. He did not write an agreement about the position of this college warden or watchman. And thirdly, Henry VIII clause came. There is some mischief. So what is the mistake? Then they have cleared the interpretation by saying that so Henry VIII clause is applicable because it is given by Henry the king. You can't oppose the same command of the sovereign. At the same time, this man, since he lost his living or shelter, then he has to provide another accommodation. So in the mischief rule, the court will decide what is the mistake committed. Then how to rectify the mistake? Is there any chance that any new law has to be made? All these things will be discussed in the mischief rule of interpretation. And lastly, harmonious construction. You may be knowing harmony. So ups and downs, if there are unfriends, that means if there is any conflict of law with one provision to the other provision, then they have to apply the so-called harmonious interpretation. Actually, it is the enactment in a comfortable zone. So the aim is to make both the so-called provisions carry in a better way. So that is the harmonious interpretation. So in this case, Venkatramana Devaru versus State of Mysore. The case is very powerful because it is a clash between Article 25 Clause 2 and Article 20. This is managing of the religious affairs. Yes, religious affairs of one particular region can be managed by their own community. But as per Article 22, it is a social welfare measure. So there's the harmonious construction there. Anyway, we are going to discuss them in detail, one by one, in the next semester. For this, I think it's getting already 12 minutes time. I am stopping here. Thank you very much.